mapawalang sala, ma-disprove ang mga alegasyon laban sa dating Pangulo. Balikan natin si Dean. Ma'am, may tanong ka kanina. In fact, yan din ang tanong ko eh. Dean, magandang gabi ulit sa inyo. Yung karaniwang sagot ng depensa, in fact, we have been hearing this from the presidential spokespersons during the time of the former president. Yan ang lagi nilang yan ang lagi nilang linya na alam niyo naman yung presidente, palabiro yan. He didn't mean what he said.
Parang nami-misunderstand
Correct.
lang. Binibigyan ng kulay yung sinasabi niya.
Will that hold? Ay, sorry. Dean, naka-mute po yata kayo?
Ay, sorry po.
Yeah, go ahead.
Depende po talaga sa nature ng mga statements, no? Yung statements po dito, technically, hindi po conclusive. May probative value po for purposes of establishing yung intent and knowledge, no? So, yung ginagawa ng prosecution dito is to accumulate the evidence. So, if they can establish na may cumulative na mga statements na ganito, yun yung parang strategy nila to establish the existence of a plan or policy for purposes of conducting this parang crime against humanity of murder. Kasi kung it's not conducted as a matter of plan or policy, if they cannot able to establish that, so yung mangyari noon, parang isolated lang yung mga killings na to, parang walang relation yung nangyari sa Davao, walang relation yung nangyari sa Bulacan and everything. So parang sasabihin nila, isolated lang mga incidents na to, na talagang walang core policy or mga ganun. But of course, so depende rin yun sa ano, no? So they were able to initially present the memorandum with respects yung operation Tokang and everything, no? So at the beginning of the presidency. So I think that's one important evidence. So I'm titingnan natin mamaya kung how will the defense respond to that particular memorandum na na-present nila. Because that's one important link in establishing yung policy consideration na these were not isolated, na talagang ginagawa ito as a matter of state policy during the presidency, from the mayoralty, and then during the presidency. So yun yung on the part of the prosecution. So titingnan natin, no? So this is getting exciting. Titingnan natin kung ano mangyari dito.
So, Dean, yan, yung binabanggit po ninyo, sabi nyo kanina, hindi pwede yung based lang sa inference. Certain words were uttered, and then certain events followed. Pero hindi pa natin ma-establish directly yung linkage ng mga events na yan. So, kung hindi ho sapat yung inference lang, ano ho yung sasapat? Ano ho yung dapat ipresenta ng prosecution?
Well, number one, they will have to establish na kada statement na binanggit ni former President Duterte, dapat may contemporaneous link yon sa isang killing or isang operation.
Kasi kung ginagawa nila, no? Parang ganun yung nagiging direksyon?
Dun sa mga
yun yung
HVP
parang
particularly.
I think strategy na ginagawa ng prosecution na yun. And then they will have to establish it was directed at certain state actors. So para ma-consider siya na parang order. Or at least kung hindi siya talagang direct na order, at least it's an parang encouragement or parang gano'n na gawin nyo to. So they will have to establish and they need to convince the court na those statements convinced the actors, the alleged perpetrators to commit the killings. Kasi ultimately, ang tingin ko dito, the defense will not actually question the fact na may mga killings na nangyari.
Yes.
So what they will be establishing here is, okay, may killings na nangyari, but you cannot attribute these killings to the former President Duterte. So yun yung magiging core strategy of the defense in this particular case.
Din, ano po sa tingin niyo yung pinaka may impact dun sa lahat ng iprenesenta ng prosecution kanina?
I think yung mga direct statements na, for example, yung sinasabi na papatayin kita, papatayin ko kayo, mga direct na mga statements. Although, of course, parang rhetoric yun. They were very strong statements. So, yun yung ano doon. So, kahit na sinabi mo yun, but still, we need the nexus. We need the link to parang ano. So, kung walang link yun, so still, magiging parang rhetoric lang yon. So at most, it can establish intent. Parang kung cumulative na talagang there's an accumulation of mga rhetorics na ganito. So parang the court may be convinced na, okay, talagang may intent. Kasi talagang sinasabi niya paulit-ulit ang ganito, no, di ba? So, pero ultimately, okay, so now may intent and then may killings na nangyari. So what the prosecution needs to establish now is the link. Yung mga statements ba na yun ang talagang nag-cause or may direct relation ba sila to the killings? So, did they killings or in parang conversely, can we say na the killing attributable or were caused by the statements? So, yung link dito, yung very important factor. So, if the prosecution cannot establish that particular link or cannot convince the court na talagang may link dito, this is not only mere inference, na talagang link na to, so yun yung talagang magiging away dito.
Dean, kanina po meron din sinasabi dun sa mga video clip na ipinalabas ni dating Pangulong Duterte na sasagutin ko lahat kapag ka merong pumatay, merong nangyari, ako, sagot ko kayo. Kumbaga, pwede ho ba yun na, sasapat po ba yun na explanation na okay, hindi ako ang gumawa nito, merong mga policeman o kung sino man na gumawa nitong mga operation
But it was
na ito.
upon my orders that
Oo,
these were carried
sinabi
out.
ko ito at sinabi ko na ako ang bahala sa inyo. Kumbaga, I take on all the responsibility.
Okay. So yun naman yung point naman yun. So they're trying to establish na he contributed, he enabled, he encouraged the commission of the crimes through his words. So ganun pa rin yung ano doon. So ultimately, yung question doon, okay. So ano yung direct causal connection nun ng mga words na yon? Yung encouragement niya, yung ba talaga ang nag-encourage sa mga police, to commit these particular killings? So the prosecution will have to establish that.
So, Dean, ang nababanggit nyo, dito ho, for purposes of confirmation of charges, hindi naman tayo guilt beyond reasonable doubt.
Opo.
Kumbaga, reasonable expectation lang na posibleng nga may nangyaring krimen at posibleng dapat itong magpatuloy sa trial. So far, with what you've heard, how is the prosecution faring towards this end?
Well, based sa pattern ng mga previous prosecutions before the International Criminal Court, this particular direction, more likely kasi, basta wala din solid evidence na, kasi dito is parang substantial evidence eh.
Yes,
So parang substantial ground to believe eh. So hindi pa naman na talagang dapat na ma-convince tayo na talagang responsible siya. So parang may possibility ba na responsible siya? Do we have, is an ordinary person, in the mind of an ordinary person, may substantial ground but to believe that these crimes may have been committed and that the former president, is responsible for or may have contributed to the commission of these crimes. So if the court is they will bring this to trial. Yun yung normal course of action. And then doon na lang sa trial yung actual na war of evidence, with the presentation of all the witnesses and
Pero din yung diskarte ng prosecution at this point. Kasi we know that at this point pwede na sila magpresenta ng mga testigo. Pero hindi pa nila ginagawa.
Normally po hindi po nangyayari yun sa
Hindi sila nagpe-present ng witnesses talaga.
confirmation hearing. Opo. Yung procedure po natin dito normally sa confirmation of charges hearing, what they present is just parang yung core theory ng kanilang case. And then they will be presenting yung kanilang summary evidence. And then minsan may mga prior recorded testimony na nakuha nila. But yung actual presentation of the witnesses, normally nangyayari po yun sa actual na trial.
Sa mismong trial.
If this goes to trial, then doon na po yung mga presentation ng mga witnesses. But in this particular case po, yung sinasabi dito, hindi po ito question of the evidence, question of sufficiency. So parang ina-assume natin na assuming na totoo lahat yung mga evidence na presented by the prosecution, so would this be enough to bring him to trial? Parang ganoon. But of course, if the defense can also attack the credibility or reliability of the evidence. Pero kung, like for example, in this particular case, these are publicly available na mga videos and everything. So I don't think they will be questioning yung credibility kung totoo ba tong video na to. So I don't think there will be questions of that nature or there will be a challenge to the evidence of that nature. So parang mangyayari dito, okay, assuming na ganito yung evidence, totoo lahat yung present ng prosecution na evidence, would this be enough for us to be convinced na may substantial ground to believe that the crimes were committed and that the former president is responsible for these crimes, or this can be attributed to him.
Din yung pagtatapos po nung presentasyon ng prosecution kanina, yung parang appeal to the emotion siya di ba? Na binanggit po si Kian de los Santos at yung iba pang mga bata at menor de edad na napatay during the duration po ng war on drugs. Yung po bang mga ganito, may bigat ba ito sa pagdedesisyon ng ICC judges? Or talagang ang emosyon, isasantabi muna natin, talagang hard facts lang po ang titingnan?
Well, normally, yung qualification po and competence ng mga ICC judges, of course, mga ano po to, mga high profile na mga practitioners, yung iba po mga judges din po ng mga high-level courts sa kanilang mga respective countries. And normally, they are known for their skill in determining, in determining evidence, in parang removing the emotion from the hard facts and the hard evidence. So, tao lang naman yan. Of course, it may have some impact. And but based on judicial parang ethics nila and everything, and pursuant to the rules of procedure, normally it is expected that they will on hard facts and the evidence presented by.
Okay. Din, natapos na po yung si Mr. Edward Jeremy, isa sa mga prosecutor. I think may in-expect pa tayong isa from the prosecution. Tama ho ba?
Yeah, I
So
think
what can
yung
we
count
expect
one,
from that
yung
presentation?
i-present nila, the next prosecutor who will be speaking will be talking about the count one. Yung count one, yung incidents while the former president was a mayor of Davao.
Or wait, parang yun yata yung kahapon din, no? I think count 3, if I'm not mistaken, ito na po yata yung
Two and
ipipresent.
three
But
today, oo.
are we expecting more of the same? Sa tingin po ninyo, ganun pa rin
I think
magiging-
yung pattern
given the direction,
will be
no?
the same. I think the pattern will be the same on the for the yung it will continue na ganito. So cumulative evidence yung ipipresent nila to establish intent, to establish yung
Attribution.
widespread and systematic attack. They will have to establish yung policy. Very important kasi yung policy.
Yes.
Yep.
Yung nakikita natin so far, Mav, wala tayong nakikitang fireworks. So, walang sagutan. Ganun ho talaga ang in-expect natin dito, Din? Parang, parang take turns lang.
Wala pa pong cross-examination dito na mangyayari.
Yeah.
But there, in some exceptional cases, may possibility na magtanong po yung mga judges. But normally, based on mga previous na mga proceedings nila, medyo rare po na nangyayari yun. Normally po kung may mga clarificatory sila na mga questions lang or parang matters of mga procedure and everything. But normally wala po mga masyadong mga tanong.
Din, mamaya, inaasahan din po natin na magsasalita yung depensa. Sa tingin po ninyo, paano naman nila sasagutin? Ito nga pong mga ibinato ng prosecution dito po sa unang pagsasalita ni Edward Jeremy.
Well, I think yung main attack of the prosecution will also be on, number one, establishing na walang intent. Number two, establishing na walang knowledge. And of course, yung question of attribution and yung question of direct link or nexus. Yun po din, I'm sure, yung magiging punteriya ni Nicholas Kaufman.
Din, kahapon lang sa day 1, ilang beses binalikan ng prosecution yung mga naging pahayag ng dating Pangulo. Again, siguro po dahil dito heavy yung prosecution, ganito ba talaga kalaki ang impact nito sa tinatakbo so far ng mga hearing? Ang sinasabi kasi ng depensa, cherry pick lang doon naman itong mga to eh. Only to support the narrative that they're trying to push.
Well, ultimately, whether they are cherry-picked or not, no? So, makikita naman po yun. Kahit na cherry-pick, technically, depende rin po yan. So, it will now be on the part of the defense to establish na may mga speeches din siya, may mga statements din siya na, for example, telling the police or telling yung mga subordinates niya to ensure respect for the law or respect for the rule of law, to protect themselves and to shoot only when necessary, only in cases of self-defense and everything. Now, yesterday they were saying na parang they were making a count, no?
Oo.
Kung ilan yung mga ganitong statements and ilan yung mga contrary statements talking about na no, yung parang mga statements na he was trying to tell the policeman you have to respect the rule of law and everything, mga ganon. So ultimately, titingnan natin kung ano talaga yung number nun. And for every statement na mape-present ng defense na former President Duterte parang tried to parang ensure compliance or respect for the rule of law, in effect, sa legal advocacy, that will now be casting doubt on the strength of the evidence of the prosecution.
Di
So
na,
yun yung magiging purpose nito. Kasi parang madidilute yung strength ng prosecution evidence eh. So sasabihin nila, okay, di ba, ganito yung sinabi mo, but on the other hand, sinabi niya rin na ganito. So you have to take this holistically. Ano ba talaga yung taken as a whole, ano ba talaga yung stand ni former President Duterte? Talaga bang joke lang ba yon or matter of policy? Talaga bang gusto niya maging ganito and everything? Or talagang he was just talking of the consequence na pero he did not actually intend it to happen. Parang pwede mo sabihin he intended the result, but he did not actually intend the means. Parang ganun. And the prosecution will also try to establish na to his mind, the police officers were parang respecting the law. To his mind, the defense will try to establish na to his mind, the police officers were only shooting or were only using their weapons as a matter of self-defense kasi sabi niya, that was my instruction. Parang gano'n. So while I was telling as a matter of rhetoric na ganito, papatayin natin lahat ng mga addict and everything, but he did not intend the parang unlawful means of achieving that particular purpose or consequence. So yun yung magiging strategy naman ng defense.
Depensa.
di naungkat din po yung tungkol sa mga co-perpetrators. Ano po yung bigat nun? At sa tingin niyo po ba ay kakasuhan din sila? Isa pong partikular na nabanggit dito ay si dating PNP Chief, Senator Ronald Bato de la Rosa, na siya po yung naglabas, siya yung nakapirma dun sa order ng PNP double barrel.
Normally po kasi as a matter of practice, alam niyo po in reality, yung cost of conducting this trial, the entire proceedings, medyo mahal po to. And this is being paid for by by all the member states of the International Criminal Court. And yung mandate for criminal court is only to charge and only to go after the the highest ranked leaders. So normally they do not go for the lower tiered na mga personalities po.
Opo. Pero Sir,
Kikita natin dito.
Opo,
Opo.
very interesting kasi mula Nobyembre, hindi na natin nakikita si Senator De La Rosa dahil nga po nagkaroon ng ugong-ugong na may warrant
may
of
warrant
arrest na
against
laban
him,
sa
oo.
kanya. So, you're saying di na sa karaniwan po ay yung pinakamataas lang talaga ang hinahabol ng ICC.
Opo. Normally po. Pero depende pa rin po 'yon. Depende po yan. For example at the level of senator, so they will look into yung alleged contribution and participation niya. So would that be parang in practical terms, yung point po kasi dito is to prevent impunity and to ensure na yung mga international crimes do not go unpunished. So yung titingnan nila dito, taking for practicality reasons yung cost of prosecution, logistics and everything, would it be practical to bring this para mga subordinates of the president, of the former President Duterte to trial at The Hague? So if you already have the former president, so would the conduct of an entirely new and separate proceedings for the subordinates, would that still be justified by the cost, by the practicality of the reasons? So may possibility din dito na they will have to wait first for the conclusion of the case against the former President Rodrigo Duterte. Kasi po, for example, kasi di ba may possibility na either yung options po dito, yung possible outcomes after the confirmation of charges hearing is either for the court to confirm the charges or may possibility din na the court will decline to confirm the charges. So if the court declines to confirm the charges, so wala nang basehan to still go after the other kasi kung hindi mapuprove ng prosecution yung substantial ground to believe that the crimes were committed, so there's no point na to go after the subordinates or the other co-perpetrators.
So dun sa subordinates, Dean, kailangan po panibagong kaso ito, no? They have to start from scratch. Hindi sila pwedeng gawing co-accused dito sa kaso laban sa dating Pangulo.
Technically po hindi na kasi naka-start na po yung
Naka-start
proceedings.
na, yes.
If the sabay, it will just be one parang joint trial or proceedings. Pero kung separate sila, like the jurisdiction over the persons of the other co-perpetrators is acquired or secured by the International Criminal Court much later, so it will now require the conduct of another parang complete proceedings. So back to square one po, parang new trial talaga.
So sorry din, tutukan lang namin itong punto na to, no? Kasi parang ilang araw o ilang linggo nang pinag-uusapan itong posibilidad ng paglalabas ng warrant sa mga co-perpetrators. Since they were named. Kasi dati redacted yung mga pangalan nila, and then very recently, I think last weekend lumabas yung mga pangalan ng 8, including 2 sitting senators, De La Rosa and Go, and then former high-ranking police officials.
Dating Justice
Mga
Secretary
dating
Aguirre,
mga naging cabinet, high officials din ng Duterte administration. So if they were to ask your legal advice, should they rest easy? Dahil nabanggit nga po ninyo, malabo akong pag-aksayahan ng panahon at resources ng ICC. Tama ho bang pananaw yun sa tingin ninyo?
Well, if you have to be careful, let's say for example on their part, may possibility na, as the rumors, were going around, na may warrants na against sa kanila even previously. So kung may warrants na given to them previously after the preliminary examination or preliminary investigation was conducted by the Office of the Prosecutor, so may possibility na may warrant na talaga. Now kung may warrant na talaga sa kanila na either it was issued just right after the issuance of the warrant against the former President Duterte, so they could no longer avoid the fact na may warrant na. So it's just a matter of executing those warrants. Now, assuming na wala pa talagang warrant, why were their names disclosed for purposes of the proceedings na parang nawala na hindi na na-redact yung pangalan nila? Because they are part of the narrative to complete the narrative of the prosecution against the former President Rodrigo Duterte. So kailangan yung participation nila because they will complete the narrative. So hindi pwede na they will not be mentioned as co-perpetrators. Right. So parang yun yung direction na that the prosecution is going to.
Just to complete the narrative but not necessarily to hold them accountable for the same crime.
Possibility. Yun yung isang possibility.
Yes.
Pero din sa kasaysayan po ba ng ICC, nangyari na ho ba na meron din silang hinabol na, ayan po, police chief o member ng gabinete o talaga pong yung state leaders lang talaga ang pinupuntirya po nila?
Heads of state, oo.
Hindi naman po. May mga cases din po ng mga lower na mga officials. Pero kung mga rank and file lang po talaga, normally hindi. So normally you have to occupy a parang malaking leadership role in the government. Parang important roles po talaga. Pero like a senator, like former PNP chief or something, may mga time na they can be included as co-perpetrators. Pero at the time of the investigation, if the International Criminal Court actually intended to bring them to The Hague as co-perpetrators, dapat po nasama na sila technically sa warrant.
At saka kasi...
To complete the narrative. Pero hindi sila nasama sa original na warrant. So the original warrant only contained the name of the former president. So I don't know what was the intention or what was the strategy of the Office of the Prosecutor at that time, whether to have a separate trial for them. Pero kung nakita mo na at that time, after concluding your investigation into the drug war, and then nakita mo na yung kanilang participation, there was no point in immediately securing a warrant for them.
At saka din kung maalala natin kay dating Pangulong Duterte, secret pa nga yung arrest warrant niya. Tapos made public lang parang 2 or 3 days after. Pero ngayon, ibinulat-lat na lahat ng pangalan. Kaya nga parang, kumbaga, may warning na sila kung sakaling mabibigyan man sila ng arrest warrant.
Opo.
Ayan. Din, maiba lang po ako. Lagi pong nauungkat yung bilang ng mga kaso na dinala sa ICC. Pwede po ba nating ipaliwanag ulit kung bakit po mula sa libu-libong naitala na nasawi dun sa mga police operation, ganito lang po karami yung umabot sa ICC?
Well, number one yung mga documented na mga cases, no, yung sinasabi natin ng mga thousands and thousands. Normally, those are the records, mga estimates ng mga either mga NGO or mga human rights organization. But for purposes of prosecution, hindi mo pwedeng isama yung ganung number because that will be logistical nightmare because you will have to establish each and every of those killings if you will include them as part of the counts. So dapat mag-concentrate ka lang talaga to the actual killings na talagang pwede mong ma-prove with evidence and with... So you will have to ultimately decide ilan yung isasama ko sa count 1, count 2, and count 3 na that will still be enough to establish the crime charged. Parang gano'n. So, importante lang dito, this is not ordinary murder. So, crime against humanity of murder. And crime against humanity of murder, normally, yung normal na ano natin, is dapat may multitude of killings, multiplicity of killings. So, kung sabihin natin 76, 70 plus, in some cases, pwede na yon, enough na yon na you can establish that there has been a multiplicity of killings. So, you don't actually need to prove na 32,000 or several thousands in order to establish the crime against humanity of murder. So yun yung naging direction and decision ng prosecution. Let's just focus on a number that we can manage and a number that we can prove.
Din, para lang din maintindihan ng mga manonood natin, yung pag-redact sa mga pangalan, bakit ho may mga pangalang nire-reveal, may mga pangalang nire-redact?
Yung redacted po ng mga pangalan, those are normally the victims. And that is for the privacy and security of the victims.
But then some were revealed. Bakit po? Ano kaya yung basis for choosing which ones to reveal?
Yung ni-reveal po, yun yung mga victims na publicly known na po yun. So for example, kung sabihin mo si Kian, so that's already publicly known. So there's nothing more to hide, no? Pero yung actual na witnesses, like who will testify about this particular killing, so yun po yung nire-redact because we're talking about actual people who will be taken to the Hague or, who will be testifying either through video link or whatever, means that the International Criminal Court will use, no? So this is for yung reduction po nito, this is for their security and safety.
Din, susunod na yung submission of merits ng counsel naman po ng victims. Ano po yung aabangan naman natin sa kanila?
Yung based on the opening arguments, so binigyan na po tayo ng roadmap, no? So yung magiging major core argument nila will be to distinguish yung rhetorics and the arguments. So sasabihin nila yung mga rhetorics na to, kahit na very harsh yung language, kahit na very incendiary yung language, pero still, para mga hyperbole lang to, these are just exaggerations, they were not really meant to be taken literally. So I think yun yung talagang magiging direction nila. But I don't think they will still be questioning whether the murders or whether the killings were actually committed. No. So they will just be focusing on the language and then they will be attacking yung question of attribution. Okay, so nagyari to, but can we really attribute it to the former President Duterte? So yun yung magiging attack nila.
Din, I think you're referring to the defense, pero ang kasunod po niyan yung sa mga biktima naman, yung common legal representative of the victims. Kahapon po sa kanyang opening statement si Attorney Joel Butuyan, isa ho sa mga binigyan diin niya ay yung kahalagahan that ICC acts on this. I mean, allows this to go to trial dahil it's the last boat, ika nga nila, for the voyage in search of justice. Bakit ho kaya ganun yung nagiging tema, yung tono ng abogado ng mga biktima?
Well, actually, I expected na talagang he would be going into the evidence, no? Kasi yung talagang role ng counsel for the victims is normally to assist the prosecution, like highlighting certain evidence na talagang may impact na talagang may relation may relation in establishing the charges. So normally yung participation ng counsel parang dapat talaga din talaga evidentiary. So hindi na dapat talaga na parang rhetoric lang. Well, of course as an appeal, you know, parang yung ginawa niya parang appeal lang to the International Criminal Court, appealing to them na talagang how important is the prosecution to them and the conviction to them, to the, you know, for the vindication of the victims and everything. So yun yung naging point niya.
At mahalaga rin po
But
kayang
he did not
patunayan.
actually focus on the evidence.
Yeah. Mahalaga rin po kayang patunayan nila na hindi kayang litisin ang mga kasong ito sa Pilipinas. Kaya sila dumudulog sa ICC.
Well, technically po kasi yung question about jurisdiction and admissibility technically po na settled na.
Yes.
So the court has already previously decided na it has jurisdiction and this case is admissible under the Rome Statute. So technically po wala na po yung ano yon, it was already, those issues were
Kumbaga,
already
dead-end
previously
argument na yan,
decided. Well, although of course pwede pa rin pong erase ni Nicholas Kaufman yung mga issues na yon, and in fact they were parang at some point or I think at the beginning of his opening statements na he alluded to the fact na walang jurisdiction yung International Criminal Court na parang former President Duterte was just hold to the parang mga ganun. So pero yung point dito, yung tapos na yung question about admissibility and jurisdiction.
Dean, maraming salamat po for your insights. Pansamantala, magpapasalamat kami sa inyo dahil mukhang magpapatuloy na. Ay, hindi pa.
Opo, sige po.
Ay, wait. Hindi pa. Naka-standby lang. Anyway, inaasahan nga po natin yan, yung susunod na, yung lawyer for the victims. We're not sure kung si Attorney Joel Butuyan pa rin ang magsasalita, pero nandun din si Attorney Gilbert Andres for the victims.
Dean, baka meron pa po kayong gustong idagdag doon po sa mga takeaways ninyo, personal na tumatak po sa inyo.
Observations,
doon
yes.
po sa prosecution presentation kanina.
Well, at least sa mga law students, so message ko lang talagang tutukan nyo tong kaso na to. And this is a big opportunity and nakita nyo na yung possibility that we now have some Filipino lawyers on the international stage, So this broadens yung mga opportunities for Filipino lawyers na when you go to law school, hindi lang parang yung dream should not be limited only to domestic practice of law sa inyong mga lugar lang, but as we have seen here, talagang may area of international practice that is ripe na and fresh, ripe na for Philippine lawyers na to take advantage of. So yung international law, particularly international criminal law, so it's one thing na talagang dapat nilang and para maging magiging possible area of practice rin nila ultimately. And of course for mga human rights lawyers and lawyers involved in the protection of the victims, so I salute you for that, So yung participation nila dito, of course, it's not easy. And so it's one thing, So ganito yon. So for mga new generation of law students, so watch out for this. So this broadens yung area of practice nyo. So this is something na talagang dapat tutukan nyo rin.
And after watching you tonight, marami hong gusto magpakadalubhasa niyan sa international law tulad ninyo. Babalikan po namin kayo. Dean
Sige po.
Ralph Sarmiento, thank you, sir.